Joining us right now is Mr. Mahesh Jethmalani. Thank you very much, Mr. Jethmalani. The first and the most important question over here is whether this is a case of a disqualification of an MP. What are your views?
Yeah, I mean, the law mandates that, it's not me who says it, it's the law that mandates that if you've been convicted for in any offense, and the sentence for that conviction is 2 years, right? Not less than 2 years. So then, of course, you stand automatically disqualified. Originally, it used to be that it took effect 3 months after. There was a provision under the Representation of People's Act. But the Supreme Court has struck down that and says Parliament has no right by law to postpone the date of disqualification by 3 months. It will take effect immediately upon the conviction and sentence.
Mr. Jethmalani, you see there is a slight catch here, and I want to understand from you, how do you view this? You see, the judgment itself the decision has been suspended for 30 days to allow appeal. Now, does that change or does that have any, perhaps any impact on a disqualification? Because the Congress feels it does.
No, I think, Sanket, I don't think the judgment has been suspended, because the trial court, only the appellate court has a right of suspension of a conviction, right? The court which passed the conviction order, that is the trial court, doesn't have the power to suspend it, right? It can't do that. What it's done is, it's granted him bail, right? So the sentence and the conviction stands, but he's been granted bail, so he's not taken into custody. Were the court not to grant him bail for a period of 30 days, right? Then he would have to surrender to custody, because he's then a convict. So they've given him 30 days to appeal, and pending that they kept him on bail. But neither his conviction nor his sentence has been suspended.
So you are, from what I understand...
So the Congress has misread the judgment.
So Mr. Jethmalani, for the benefit of our viewers, because this is an important and critical technicality, the Congress is,
yes,
giving us to believe that there is a suspension here of the decision, which then gives him that much time. So you are saying that there is absolutely no impact.
No, that's not. There is no power of the trial court to suspend a sentence and conviction passed by it. There is no power, right? What it can do is it can release him on bail for a particular period of time till he files his appeal. So he doesn't have to surrender to custody. Right now, his conviction and suspension stands. It has not been set aside by the trial court. Indeed, the trial court has no power to do so. But the trial court has given him the facility of appealing for 30 days, and during the 30 days, it has released him on bail for 30 days. Till then, he has to get an order. Either the court will dismiss the appeal, right? Or it will stay the sentence, or it will stay the conviction and sentence, or it will release him on bail so that he doesn't have to surrender to custody. There are 4 options left to the appellate court. But it's all in the hands of the appellate court.
But either way, you are saying that the law as of this moment stands as of 10th July 2013, where anyone who is convicted, then that public representative, he will have to step down, or he'll be removed from public office.
He stands immediately disqualified. That's the law by the Supreme Court in 2013, right? Now, he stands immediately disqualified, but he can exercise his right of appeal. And as per that judgment of 2013, if he succeeds in getting a suspension of his conviction pending his appeal, that disqualification stands in abeyance, and he can continue to be a member of Parliament.
And I think that's the point that many in the Congress are making about, exploring all legal options. So you feel that that legality still exists in favor of the Congress for him to continue as an MP?
Well, if he goes to the appellate court and he gets a stay of conviction, it will. I mean, it happened in the past. It's happened in the past. After the 2013 judgment, the Kerala High Court has done that in some case. Of a sitting MLA or MP, I'm not sure.
Mr. Jethmalani, is this a case of
it stayed his conviction?
Is this a case of immediate disqualification or subject to reasonable rationale discussion or can the Speaker in his right take this decision? Is this the Speaker's decision now?
No. By operation of law, he stands disqualified, right? He stands disqualified, but the decision has to be communicated to the Speaker. But as of today, the moment the conviction order is passed and the sentence is 2 years or more, right? The accused person, if he's a member of parliament or a member of a legislature, he stands disqualified from that post.
Now,
so it's by immediate operation of law.
Mr. Jethmalani, now this is about, how the law should be read and whether there should be an immediate disqualification or not. Let's now talk about this very case itself. The Congress party feels that the manner in which this case has been processed in courts, that many different Modis have objected to the statement and, these proceedings have taken place. It just makes the whole process political in nature. I'm not commenting on the decision of the court, but the manner in which it has been pursued in court.
What do you mean the manner in which it has been pursued? Listen, there is a section 499 and 500 which together encompasses the ingredients of the offence of somebody has been aggrieved. That person has gone to court. He's what's called the complainant. After a full-fledged trial in which Rahul Gandhi, presumably through his lawyers, has cross-examined him, have raised all their defences, he has been found guilty of that particular offence, and he's got the sentence of 2 years. So what do you mean the process is tainted? I mean, all these cliches and shibboleths which the Congress keeps using are pure obfuscation. It's a very simple matter. I mean, you want to confuse the layman, you can. They've been doing it all the time. I mean, Rahul Gandhi says this all the time. He says Pegasus, that my phones were tapped by Pegasus, and he refused to give his phone. So, I mean, what are we talking about? It's a very simple thing. We don't have to go into verbal obfuscation and some kind of semantic fraud.
I'll tell you another point that is being made. That by disqualification, you would have Rahul Gandhi out of parliament, and then he will not be able to accuse the government and exert pressure for an inquiry into the Hindenburg report.
Look, these are all, I don't know, these are all Congress strategies. You're asking me about Congress strategies. Most of the time I'm not aware of them. Most of the time I can't understand them, Sanket. So what are you asking me? You're asking me to comment on the Congress strategy. I don't know. Well, good luck to whatever strategy they want. Most of it has been misconceived for the last so many years.
Mr. Jethmalani, there is another important question over here, and many lawmakers have raised this in the past. They say that there is a very strong need of decriminalizing the defamation law because it is not used, in fact, it is used in a very unjust way. How would you respond?
Well, let me tell you, the Congress is now trying to shut the stable door after the horse has bolted. Subramaniam Swamy took this matter up and said precisely the same thing. He said that the criminal defamation law needs to be quashed because it's violative of Article 19(1)A, the freedom of speech clause, right? And the Supreme Court has rejected it. So, Congress has suddenly woken up and it affects one of them or their leader.
No, it's not just the Congress. You see, even the Aam Aadmi Party, Raghav Chadha says that he is going to, ask for an introduction of this bill because his own leader, by the way, has faced many defamation cases, criminal defamation cases.
Yeah, but so these are people who believe in the right to abuse freely and then not stand up for what they say.
There's also an allegation, Mr. Jethmalani, that
if you want
the rule is not evenly applicable. I mean, there are many cases where some extremely defamatory comments have been made by senior BJP leaders, and the Congress and the Aam Aadmi Party alleges that the Prime Minister himself uses expression like 50 crore ki girlfriend, raincoat for the former Prime Minister, and many others. I mean, you would know. I don't want to repeat all of them.
I see. I don't know what are the exact defamatory cases, but so far nobody has filed a defamation case against the Prime Minister. So obviously there's been no substance in what they're saying.
Okay. In the end, Mr. Jethmalani, I just want to ask you this question. So from what I understand that you have just told us, there is a case of immediate disqualification because that is what the law suggests. That is what the not
Yes.
suggests. That is what the law says.
Yes.
But there is a technicality that the Congress can exploit to continue with the membership.
Yes. Yes, of course. It's not a technicality. It's a, please don't call it a technicality, Sanket. It's a substantive right of appeal. He has a right of appeal. He can go to the Sessions Court and seek a stay of his conviction and revive his right to be a member of parliament.
All right. Mr. Mahesh Jethmalani, thank you very much for joining us. Thank you so much.
Thank you.